Karno, Nilimen Thari Sarko Imtiron Mili, but hot Nili, the Karbi law vision and Hipanatum Han, see lower topic like judicial review, the Banso topic once, and little Han Pin, the Banso, Lamarjan Tiek and Pondapompo. See Toilitum Chinilanang, judicial review, Pulangi Litum like Article 13 of the Indian Constitution, mainly best. See Article 13 along on see Indian judiciary system so power of the judicial review ka confers mati like tum plan man see first judicial review along ini tum damdian ko di koson sila bangsa doctrine ke plan lo ilum chini lo nang to tang ti tum cheng lo nang apor de pin pen ke cheng si ke lake the doctrine of judicial review originated and developed in the USA like apang si ki India long na ke plan koson kali la bangsa judicial review doctrine ke like USA long sa ke plan cheng Koson si USA no nake plan ma la bangso case laws ni thi hek pen pak lang ji ili tum judicial review to pig man ching cheng ko nga si it was propounded for the first time in the famous case of Marbury versus Madison di hala bangso 1803 aning kan USA long Marbury versus Madison la bangso case along si Supreme Court Chief Justice American Supreme Court Chief Justice John Marshall alang di pensi labang so judicial review pinia bangke doctrine manke propound pon lo nasi dahil itum ke top heglong lo it was propounded for the first time in the famous case of Marbury versus Madison in the year 1803 by John Marshall then Chief Justice of the American Supreme Court si that pu nasi tawtan hilum Indian Constitution along possible itum che thana pot Indian Constitution ko son si judicial review of power ki dum la le mambang itum na control nang la USA long man ke plan cheng no la bangsa doctrine ngasi in India di on the other hand the Constitution itself confers the power of judicial review on the judiciary both to the Supreme Court and to the High Court di la silin nang nang further Supreme Court declared that the power of judicial review as a basic feature of the Indian Constitution possible. Lapen also further di in Supreme Court atum declared law ye judicial review ke lake as a basic feature of the Indian Constitution. La totally basic feature totally as an element of the basic structure of the Indian Constitution. Pusi lamang so judicial review a provision Article 13 of the Indian Constitution upon a Supreme Court atum manke interpret pipono. Kasi ito na hence daki po bang lapulo the judicial review cannot be curtailed or excluded even by a constitutional amendment possible. Kasi judicial review power ke lake constitutional amendment peleklen pusi tame cannot be curtailed and cannot be excluded pusi daki po ate people lasun ki po bangke lake judicial review bang non bangke basic feature of the Indian Constitution lapen it has also become a basic element of the basic structure of the Indian Constitution pusi that pool. Now see non ilitum similar like si basic feature mate basic structure of the Indian Constitution apart man dalo judicial review bangke sitame labang so meaning di judicial review meaning de ilitum sini nang ko mate di lasi itu that meaning lam nang judicial review meaning mang ladak lason si puho it is the power of the judiciary to examine the constitutionality of legislative enactments and executive orders of both central and state governments pusi dak pulo and if they found to be violative of the constitutional ultra-vires then these laws can be declared as unconstitutional possible illegal and null and void let's see by the judiciary and consequently such laws cannot be enforced by the government that pulo judicial review pulang nang lagi isi power of the judiciary branch na tumjong si kupine isi parliament tum law se marlo mati law one law pero hala bang so law constitutionality kanima kalang madi na tum legislative and enactments la ke executive orders ke to any of the central government or state governments la tum kasi mar law anjong si constitutionality mate constitution aphan kupine hampers do ma intervene ma yung si intravent that lapen ko pini hampers that po nakala bang solo pan ke ultra-vires po lapen ke ultra-vires po tante labang so these laws will be regarded as unconstitutional illegal la pen ke null and void pusi judiciary to mang declare la ja kong do hala bang so ja kong phansi judicial review a power ke kipu la pen article 13 di article 13 ke la ke kai ke the protectors of the part 3 of the Indian constitution part 3 bodi dum chimil la ke part 3 of the Indian constitution la ke fundamental rights along si mainly deal di la si la no nang itum famous justice Syed Shah Muhammad Kadri alang ni la ke justice Syed Shah Muhammad Kadri alang ni la bang so judicial review upon 3 categories alang ni divide lo la pen bang so 3 categories alang ni justice Syed Shah Muhammad Kadri ka divide pon man ke la hilo judicial review of constitutional amendments isilo la pen hiniel bangke judicial review of legislations of the parliament and state legislatures and subordinate legislatures la pen ke tulang judicial review of administrative actions of the union and state authorities under the state di la ke thom hello justice Syed Shah Muhammad Kadri bangke ke divide pon categories lo sili tum la monang in the year 2015 ilitum chini lo Supreme Court declared both the 99 constitutional amendment 2014 and the National Judicial Appointments Commission NJAC Act 2014 as unconstitutional and void. That's a little technology law judiciary power exercise in the year 2015. Athila 2015 and in Karabang Supreme Court atum declared dud lo ana jak kong judiciary jak kong cepak lang lo 99 Constitutional Amendment Act 2014 la pen ke the National Judicial Appointment Commission NJAC Act 2014 aphan posisame lake contravene la pen ke Indian Constitution aphan kopine ultra-vires kusipula la pen la bangso alu mate enactments upon manke null and void la pen ke unconstitutional pusi declare upon them la sila monang importance of judiciary no itu la monang people see importance of judiciary la pen ke judicial review b importance of judicial review ki do kok man ko athe man ke la lo itum chini lo to uphold the supremacy of the constitution d ati judicial review se away polotan de jata lo le parliament atum selam non ba state legislature atum selam pusi tame da ke check dun je ta abidat po aning aning parliament tum law se marbaret po hala bang so ke check dun je phan public upon fundamental rights upon kai kita ka violate ka bidat nang lo personal law se mar nai kai kita ke lang lo be je phan si la bang so ja kong bang ke judicial review under article 13 of the Indian constitution bang ke judiciary atum phan bidat lo Supreme Court High Court atum phan si la pen ke number 2 bang to maintain federal equilibrium di balance between center and the state athi Indian ke itum ke federal quasi federal pusi pustami itum ke federation di itum Indian government ke federal form of government itum full fledged federal government pula pupi sita Indian constitution long si pulo itum ke quasi federal government di India long ke asi quasi federal pota na ke divisions of power do center and the state di itum ke unitary form of government kali lasi laso center and the state ang bong kai kita conflict ka bide si aphan la song bong balance ke maintain ji aphan pu power sang mo la tum ka che phul ok li de ji ko conflict ka bide ji aphan si la bang so ka maintain do ji aphan si judicial review power bang ki pinang ko ta isi lo la pen ke thom lam thu na ke thom lo bang ke to protect the fundamental rights of the citizens di athi judicial review power in si judiciary to phan pp under article 13 pp pulotan pe Ajata lo le parliament na tum selam puisa mo pinapen ke fundamental rights na ilitum phana pa pilapo ng cartel pilapo laso ka pheri joni si fundamental rights of the citizens se kita alam tunong dober nang ji tapen ke latuma rights fundamental rights ke pavir pilong le tapen laso ke check and balance ka ke lang no je phana ke judiciary system atum se ajabu nang ji bo phansi lamang so judicial review power banke piponang koklo lasi la hello importance of judicial review ini tu kupi posing nang sok ke sini dam nang ji pulo nang pe la pen la kam tu nang bi noi tum thigam long lo court di Supreme Court pulo nang la ke Supreme Court is the final interpreter of the constitution or the law of this land to determine the powers of each branches of the government dak pulo hari judiciary mate Supreme Court tu hello final interpreter lo bang joka bang pule constitution of han ke la puson la pu pule nang phas tame leke authentic kalilo tapi itu sini lo nang kai case tame final interpreter of the constitution ajata law tame interpreter final interpreter ke lake Supreme Court kali de High Court hello last lada kapang ke there are three branches of the government itu sini lo di legislative, executive, lapen ke judiciary nasla ke thom branches ang mong kai kita kachi pholok le ji aphan amithang la ke thom branches ta amithang power kachi chini rep pen isi along with India nation aso si kapang tang along with paman ji aphan kai kita ki check le phasi so judicial power mate judiciary branch man ke ki pinang kok lo kali purotang ti three branches of the government the executive legislative lapen ke judiciary la thong ji phodu ji conflict do kok po ada tinta pila puji challenge for hegemony ni to power si on parliament on the challenge for legislative la lapen ke la executive atum ta lapen ke judiciary tum ta la si article 13 ke judiciary to phan ke judicial review bolang power ban pinang kok lo la sili tum nang isi hini constitutional provisions of the judicial review di nilithek pen popo article 13 pula hadi all the laws that are inconsistent with the fundamental rights of the Indian constitution of hanke lake null and void pusi article 13 pulo ajata law le parliament mein salam pusi tame jongsi fundamental right are against mate inconsistent with fundamental rights of the Indian constitution or inconsistent with the part 3 of the Indian constitution halaphan pulo tangke null and void pusi under article 13 pulo la banke dake judicial review of power below la banke lam pulo nang article 32 of the Indian Constitution it guarantees the right to move to the Supreme Court for the enforcement of the fundamental rights and empowers the Supreme Court to issue direction or orders or writ for that purpose. Jong sinangli fundamental rights pinya ina violates the state government atum punon Indian government pulutang tinangli under Article 13 of the under Article 32 of the Indian Constitution ating pinangli Supreme Court ang appose damun sitamelake violation of fundamental rights Panchoji, the Peke, under the 5 breach of the Indian Constitution, Noxi, Nandi, Halaswa, provisional Lucy Dampo. Lapenke, Gatulang, Article 131, provide, Jongsi, Center and State and Mongdi, could be interstate dispute to court. Example like Assam State Pen Government of India, Mong Government among Chiton, they conflict the court case, Kachetan, Posam Banke, final interpreter under judicial review, Pusitame. Judiciary atau Supreme Court tum si nine side mo government mo char mo pulo tangte la sila hello isor bangke la pen lagi itu lam thulo nan Article 226 of the Indian Constitution ta itu hana empowers law jong sinangli fundamental rights of citizen violates that pulo tangte government atum nangli fundamental rights of kai kita nang pasiksak pulo tangte nangli Supreme Court kanilo la bangke direct High Court of nangli opportune under reach of the provision under which provision ating pen nangli High Court upon a post tamulo lahelo laham thun nang lapen cholo nilila provision upon la pansi paklang kon choji samino ne important na yalam nili than thulang lapan ke judicial review of 9 schedule nali to 9 schedule opportunity machini ne ma 9 schedule potan te lage hadi under Article 31B save the acts and regulations included in 9 schedule from being challenged and invalidated on the ground of contraventions of any of the fundamental rights. Article 31B along with 9 schedule was added by the first Constitutional Amendment Act of 1951. That could have been 9 schedule along kendo acts lapen regulation banke even nangli fundamental rights aphan violates pusitame lapen constitution aphan kopine hamper do pusitame labanke challenge on a pusi pula pen lasodim la mai judicial review tumta order nongli pusi dabanke Article 31B of the Indian Constitution labanke to that no alapenke labang so Article 31B aro kedo 9 schedule aro kedo acts lapen regulations ke even nangli phan kaphiri mimi alo le do pusitame lapen nangli fundamental rights aphan violation thepic pusitame labanke you cannot challenge pusi dabanke under Article 31B of the Indian Constitution pulo lapen ke labang so Article 31B ke thap ke lage during the first Constitutional Amendment Act of 1951 and can see labang so 9 schedule Article 31B ke include lo sitami pejo pe lamang so putha judiciary tum munchi do no Supreme Court tum mathalum la puke chokche pusi the historic judgment di in IR Kolho case 2007 and in Kanabanke, the Supreme Court ruled that the laws placed under 9th schedule after April 24, 1973 are open to challenge in the court if they are violative of the fundamental rights. You see, history judgment upon Supreme Court will be that. That if you lapulo IR Kolho case 2007 and in Kanalong Banke, Supreme Court ruled that the laws placed under 9th schedule ajata laws rule regulations when act do un 9th schedule aro ke halasut ke article 31 b long bankulo challenge e punumati nami fundamental rights of violative pusname you cannot challenge possible system api Supreme Court to mang matha thudingo lake constitution of kapheri mimi thepik pusi history judgment ban pidel IR Kolho case 2007 and in Kanalong Banke la pena Supreme Court tum ja kongse paklang tudlo Hasanji paklang makelalo ajata laws rules and regulations are ekle do pusitame under 9th schedule of the Indian Constitution after 24 April 1973 pe kase maralo anke 9th schedule arule tha include dun pusitame lake if they are violative to the fundamental rights of the Indian Constitution, then they are open to challenge the judiciary pusi Supreme Court tum judgment pidalo lapen ke April 24, 1973 on landmark judgment, basic structure theory concept was propounded by the judiciary in the Kesavananda Bharati versus State of Kerala case laws. Mantum tini lo Kesavananda Bharati versus State of Kerala case kache thang nai case the Indian history lo nani tum dam pusitame dapat ke April 24, 1973 and in kansi Indian history lo ke dapat so basic structure theory ke adopt jeng Nasi sini di pacini itu lah hello nami itu sini not under 9th schedule of the Indian Constitution alu itu ana ek rules pusitame article 31 b bang gulo challenge ajata lo le do pusitame under 9th schedule of the Indian Constitution along itu ana lo ke even fundamental rights le violative pusitame you cannot challenge pusipulo sitame in the history judgment IR Kolho a case 2007 and in Kanalong bang Supreme Court atum pulo if the acts and the regulations under 9th schedule of the Indian Constitution are violative to the fundamental rights of the Indian Constitution, then you are open to challenge in the judiciary pusi pangdak that look. Nasilah lo punya topik bangke nang itu apa? Ani likewang bangke judicial review of the judicial powers of the Indian Constitution. Penhala bangso article 13 ben kibi for judicial review of power judiciary itu kan. Sili sini lo nang judicial review pun nang leke check and balance kai kita parliament tum kasi mar alo han kelang tuna lo apen kela swaja ko mangili tum kado kabita respect nang ji najong sawi pun di tum a country along with kacharia mangi constitution mak idea bedaji asi constitution halo ke nai alo lo constitution along ke do ke to ateng ji ajat branches 3 branches of the government na koido nang ji pusi lada pudak lo masih nili lam ke bangke la pansi pinya video na mangi peju pun ko